Welcome to another explainer from Law Academia Global, the place where you can sharpen your legal knowledge and at the same time improve your legal English. Today we are tackling a huge topic, something that pops up in everything from employment contracts to massive corporate deals: arbitration. You might have heard it called the private trial, and we're about to find out exactly what that means.
So, picture this. You find yourself in a legal dispute, and just the thought of a court battle, it's long, it's public, it can be really intimidating, it's an ordeal. But what if you could just skip all that? What if there was a different path, one that promised to be faster, quieter, more private? Well, that is the promise of arbitration.
Okay, so what is this thing really? At its heart, arbitration is a way to settle a fight without ever stepping foot in a courtroom. Instead of a judge and a jury, your case is heard by a neutral person, an arbitrator. And I love how the source material puts it. It's basically a paid private trial. You're paying for a private justice system. But the big question is it always the right move?
So here's our game plan for this explainer. We're going to make sure we're all on the same page about what arbitration is. Then, we'll look at all the reasons you might want to choose it, the case for arbitration. After that, though, we'll flip the coin and dig into the hidden downsides. Then, we'll get into the really tricky part, how some of its best features can also be its worst. And finally, we'll try to land on some kind of final verdict.
All right, first up, let's just quickly lock in our understanding of this alternative to the traditional court system. Now, let's explore the arguments for arbitration. Why do so many people and companies find this promise of a simpler path so attractive?
And looking at the highlights, you can immediately see the appeal. These are the big selling points, right? It's efficient, it's private, you have some control, and when it's over, it's over. Let's break down a couple of the most important ones.
First, and this is probably the biggest one, speed. Court systems are just famously slow. They're backlogged. You could be waiting for years, literally years, just to get your day in court. But with arbitration, you can often get a hearing scheduled in just a few months. When time is money, that is a game changer.
And you can see the difference in how things actually get done. Court litigation is this very formal, rigid dance of filing papers, making motions, showing up for hearings. It's complex. Arbitration, on the other hand, cuts through a lot of that red tape. So many issues can just be sorted out with a few phone calls. It's a much more streamlined process.
And then there's privacy. This is huge. Court proceedings, they're public record. Anybody can look them up. If you're a business trying to protect your secret sauce, or maybe a celebrity who really doesn't want their personal life all over the news, that's a nightmare. Arbitration happens behind closed doors. Everything, the evidence, the arguments, the final decision can be kept under wraps.
So, it sounds pretty fantastic, doesn't it? It's faster, it's simpler, it's private. But what's the catch? What are you actually giving up to get all those benefits? This is where we have to look at the other side of the story.
And that brings us to the most important question of all. When you strip away all the rules and protections of the court system, can you be sure the process is actually fair? Because the sources we looked at raise some really serious questions about that.
And this is just so important to understand. When you agree to arbitration, especially when it's buried in a contract you signed maybe years ago, you are waiving some of your most fundamental legal rights. The right to a jury, gone. The right to appeal a bad decision, gone. The guarantee that the person deciding your fate has to follow the law to the letter, that's gone too.
Let's just focus on the jury part for a second. The whole idea of a jury is to have your case heard by a group of regular people, your peers, to protect against a single person's bias. In arbitration, that's completely out the window. You have one person, the arbitrator, who acts as both the judge and the jury. They hold all the power.
So what can happen? Well, you can get a serious power imbalance. This quote from the source really hits the nail on the head. Think about it, a big company versus a single employee or a customer. The company has done this 100 times. They know the system. The individual? They might have no idea what they've gotten themselves into or what rights they signed away in the first place. Okay, now we get to what I think is the most fascinating part of this whole discussion, because it turns out that some of arbitration's biggest selling points are also its most dangerous traps. They are a classic double-edged sword.
Let's take finality. On the one hand, hey, that's great.
The arbitrator decides, and boom, it's done. The fight is over, no more lawyers, no more stress, no more bleeding money on appeals. But look at the other side. What if the arbitrator just gets it completely wrong? What if the ruling makes no sense and ignores the law? Well, too bad, because the decision is final and there's almost nothing you can do about it. You're stuck.
And this quote just says it all, doesn't it? Both sides give up the right to appeal. If you win, you're relieved. But if you lose and you feel the decision was just plain wrong, you're at a dead end. There's really no second chance. This might be the single biggest gamble you take with arbitration.
It's the exact same paradox with cost. Yeah, we said it's usually cheaper because it's faster, but that's not a given. See, in court, you don't pay the judge's salary, right? The taxpayers do. In arbitration, you and the other party have to split the cost of the arbitrator. And a good, experienced arbitrator, they can charge a lot of money, which could actually make the whole thing more expensive than court.
So, after all this, where do we land? What's the final verdict on arbitration? Well, it's all about weighing the trade-offs.
This table really just lays it all out so clearly. Every single pro has a matching con. The rules are simpler, more flexible, but that can make the outcome unpredictable. The decision is final, which is great for closure, but terrible if the ruling is bad. The process is private, but that lack of transparency can hide potential bias. You see the pattern here? It's a series of trade-offs.
So in the end, there's no easy answer. The question isn't, is arbitration good or bad? That's the wrong way to think about it. The real question is whether it's the right choice for your specific problem. It all comes down to what you care about most. Do you prioritize speed and privacy above all else? Or are the protections of the court system, like the right to appeal, more important to you?
And that really leaves us with the one final critical question that you have to ask yourself before you ever agree to arbitration. Is that promise of a quick and quiet resolution worth the massive risk of being stuck with a bad ruling forever with no way to fix it? The answer, as we've seen, is complicated, and it really depends on what you're willing to bet. Thanks so much for joining us for this explainer. We encourage you again to listen to our podcasts as well for more deep dives into legal topics.